Multiple lawsuits have been filed in California that are very geeky, but extremely important to your right to keep and bear arms in the Golden State. Because if these lawsuits fail to knock down a California law that basically punishes anyone that sues under the Second Amendment and doesn't win the case entirely, 1,000% of it has to pay major attorney's fees to the state of California. And if that law stands, it will basically discourage, if not eliminate, all Second Amendment lawsuits challenging their unconstitutional gun laws forever. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gunner, best-selling author, constitutional attorney, and member of the United States Supreme Court Bar. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so and show your love for the right to keep and bear arms. And feel free to follow us on Twitter at Four Boxes Diner. We're trying to spread the word about this channel all the time now. 2 major lawsuits have been filed. I'll put the links to them down below. Basically, everybody who's anyone in the state of California litigating on behalf of the Second Amendment is involved in these lawsuits as best as I can tell. Why is that? These lawsuits are challenging a law that we talked about a month or two ago in California, which is a California state law that essentially punishes, literally punishes financially any person that sues under the Second Amendment, including their lawyers and their law firms, unless they win entirely. What do I mean by that? Basically, what California did is says if you bring a lawsuit challenging any gun control law, gun regulation, and you do not win every aspect of your lawsuit in its entirety, then you are deemed a losing party. And California, the state of California, or any of the subdivisions, any of the cities, any of the towns, any of the villages are deemed prevailing parties. And as a result, the prevailing parties, meaning the government of California or any of their subdivisions, like cities or towns, can sue not just the people that brought the lawsuit, but also the lawyers that represented those people for damages, including their entirety of their attorney's fees, which will be literally hundreds of thousands of dollars per case, if not millions of dollars per case, that the plaintiffs who sued to challenge unconstitutional laws under the Second Amendment would have to pay. The reality of that is this, that if this California law stands, that basically threatens with financial ruin the people that sue under the Second Amendment as the plaintiffs, meaning individual gun owners that are suing not because they're going to make any money, but because they want to vindicate their right to keep and bear arms, and the law firms and the lawyers that represent those people, no one's going to sue anymore. No one will sue in California. All those lawsuits will be deterred on the grounds that no one will risk financial bankruptcy, and no lawyer will be taking the case because they don't want to risk financial bankruptcy or destroy their law firm either for a legal case. And this includes organizations that basically, sue as well. So these lawsuits, again, I'll link to them down below, are challenging this California statute, and this is a must-win for the Second Amendment movement. If these cases do not prevail and knock out this California law, basically starting in 2023, any challenges to California-related gun control laws will likely simply cease to exist. No one will bring lawsuits anymore unless you're a billionaire and you don't care, and those are hard to find. That will be the reality of it. The good news is that I think this California statute that basically creates prevailing parties of anyone but the Second Amendment plaintiffs who sued to challenge the gun control laws, the good news is it's likely to be struck down as unconstitutional and illegal for at least 3 reasons. And I just want to quickly go over them. It's a little geeky, but I think it's important that you need to know this. Number 1, the reason why this California law is likely going to be struck down is threefold. First, there are federal statutes that provide that if you sue under the Constitution and your constitutional rights have been violated, or you vindicate your constitutional rights, including under the Second Amendment, you, meaning the plaintiff and the lawyers, are prevailing parties. Specifically, the relevant statute under the Civil Rights Act is 42 U.S.C. 1988. That's 42 United States Code 1988 provides that if you sue under the Second Amendment, a city, a town, a state, whatnot, you are a prevailing party, provided that you win. Any aspect of the case, you win, you are entitled to your attorney's fees. So basically, the state of California is trying to flip this on its head and give the bill to any plaintiff that loses, but this is going to almost certainly be preempted under federal law because remember this, under the United States Constitution, there's a specific provision in the United States Constitution called the Supremacy Clause. The Supremacy Clause. And what the Supremacy Clause basically says is that anything that contradicts the Constitution falls by the wayside of the Constitution. 42 U.S.C. 1988 is a federal civil rights law, federal law. It contradicts essentially what's going on with this California state law. So the federal law, because it's supreme over the state law, will trump this California law and likely cause the California law to be struck down on that ground, which is known as the ground of preemption. The second reason I think this California law is going to get struck down is because of the First Amendment. If you read the First Amendment, there is a right to petition the government for redress of various harms. So here, you're basically slamming the courthouse door shut on people that want to vindicate their right to keep and bear arms, that want to strike down gun control laws that they think violate the law, including but not limited to the Second Amendment's right to keep and bear arms. And as a consequence, by slamming the door or creating this major disincentive for anyone to sue, this is probably going to violate the First Amendment. Under the First Amendment, you have a right, again, to petition the government to redress any harms or concerns. You can petition the government. One way you petition the government in modern America is you sue. This is no different than the civil rights movement in the 1940s, the 50s, and the 60s. They were constantly suing, trying to vindicate the civil rights of African Americans, particularly in the South, although actually all over the country. Bottom line is this. The plaintiffs in the Second Amendment cases in California that want to sue to vindicate their right to keep and bear arms under the Second Amendment and other related laws have a right to petition their government. And guess what? That's the First Amendment right. And I think that this law that's basically trying to punish people for doing that is going to get struck down again, not just under preemption grounds, which you talked about, but also under the First Amendment because, again, it is an infringement, it's a tax, it's an obstacle, if you will. It's some way to get rid of the First Amendment and undercut the First Amendment, and that is simply not allowed because the First Amendment is supreme or trumps all of the laws, meaning all of the state laws, including the state of California's laws that violate it. So that's probably going to get struck down on the First Amendment as well. And the last reason why I think this California law that punishes plaintiffs and people suing to vindicate their Second Amendment rights against gun control laws in the state of California is under the Equal Protection Clause. The 14th Amendment, which was ratified in 1868, provides that all Americans are supposed to benefit from the equal protection of law, which means that everyone is supposed to be treated the same before the law. And the idea is, of course, that everyone is equal, not in terms of outcomes or equal in terms of, skill set or equal in terms of talents or anything like that, but they're equal before a court of law. That's what the Equal Protection Clause is. Here, I think the California statute violates the equal protection of law under the 14th Amendment to the United States Constitution because the California law basically says that if you're trying to vindicate the First Amendment, the Third Amendment, the Fourth Amendment, the Fifth Amendment, the Sixth Amendment, if you're trying to vindicate the 14th Amendment, if you're trying to vindicate the quote unquote right to an abortion, which no longer exists, at least under federal law, if you're trying to vindicate any of these laws, then of course you can get attorney's fees and there's no punishment if you lose or anything like that. But in contrast, if you want to sue to strike down any of our gun rules or regulations anywhere in the state of California, whether it be state, city, local, town, village, it doesn't matter. If you sue in the state of California and you lose any aspect of your lawsuit involving the Second Amendment and gun laws, then you are going to be punished. That means that you're treating the plaintiffs and the individuals suing to vindicate Second Amendment rights differently than you would for those people suing other constitutional rights like the First Amendment, the Fourth Amendment, the Fifth Amendment, what have you. And therefore, I would argue that you're not treating them equally, which is a violation of the 14th Amendment, equal protection of law, because again, you're treating different people differently, even though they're similarly situated, because they're seeking to vindicate constitutional rights against state wrongs. But if you do it for guns in the Second Amendment, they punish you by giving you a very large bill unless you win all aspects of your case, and that will be a major deterrent for suing under the Second Amendment, but that deterrent will not exist for any other aspect of constitutional challenges in the state of California, which is why I think a federal court will strike down the California and enjoin it on the grounds of equal protection. Okay, I hope you learned a little bit something about this California law, why it's so bad and why it's likely going to be struck down. We'll follow these lawsuits carefully. I'll put links down below. But again, this California law punishing people for suing under the Second Amendment is likely going to be struck down because it's going to be preempted by 42 U.S.C. 1988. By the First Amendment and by the Equal Protection Clause of the 14th Amendment, and perhaps even other reasons. Okay, hope you learned a little bit something here at the Four Boxes Diner. If you haven't subscribed, please do so, and we'll see you again here at the Four Boxes Diner.
Orders up. Table 2A.